what the Virginia law says is nobody can make our citizens buy health insurance. And that, they can say that if they want to, but under the Supremacy Clause, a state cannot tell the federal government what to do. The federal law is the supreme law of the land as long as Congress is acting within its constitutionally granted powers, and it is here.
How does the Commerce Clause play into these challenges?
Well, the Commerce Clause says that the Congress has the authority to regulate commerce among the states. And since the 1930s, that power has been interpreted very broadly. In the 1930s, there was a case where a fellow was just planting wheat for his own consumption, and Congress passed a law regulating agricultural production, and the Supreme Court said, well, you know, you plant wheat for your own use, but you might sell some of it, and you won't be buying as much, and commerce all sort of flows together, and that's part of regulating interstate commerce. More recently, a few years ago, not too long ago, a man was arrested for growing medical marijuana plants on his windowsill, and the Supreme Court said that under the Controlled Substances Act, the federal law, that was illegal. And once again, even now more than ever, commerce is all of a piece, and growing medical marijuana on your windowsill, marijuana is a huge business. Who knows where that marijuana is going to end up? And in the most recent case involving the Commerce Clause was the partial birth abortion case, Gonzalez versus Carhart, in which the Supreme Court said that Congress, under its commerce power, can regulate medical practice. It can tell doctors what they can do inside their surgeries. So basically, the law now is that if there's any kind of economic activity involved, Congress has the power to regulate it. And of course Congress does. We have lots of federal laws regulating all sorts of economic activity. Well, the decision when to buy insurance, do I buy it now while I'm healthy, or do I buy it when I'm in the ambulance on the way to the hospital, is an economic decision, and Congress clearly has the power to regulate it. And once Congress has the power to do something under the Supremacy Clause, its laws are supreme to the laws of the states, and the 10th Amendment only provides that states retain powers that are not granted to Congress. Urge someone to buy a product in the private market. And you're absolutely right. We have an activist court right now. We have a court that has shown itself willing to overturn long-standing precedents to reach political goals that it finds attractive. And that, of course, makes one a little nervous. On the other hand, I think you're also absolutely right that Justice Rehnquist and also to a lesser extent Justice O'Connor really emphasize states' rights in a way that the court hasn't for a long time. Neither of them are on the court anymore. And the precedents, there were a couple of cases one in the 1990s, one around 2000, in which the court said that Congress's power is not limitless. When it gets beyond economic activity, it's beyond the Commerce Clause. But those were 5-4 decisions. Those were decisions written by Justice Rehnquist. He is no longer on the court. And I have not seen the same kind of interest in protecting states' rights in the current court that was there when Justice Rehnquist was on the court. But even then, some people who are supporting states' rights in this area point to a handful of decisions in recent years where the courts have made some noise about you know, we need to be more deferential to the states. But in each of those cases, what was involved was interpretation of a statute or interpretation of a court decision, not whether federal statutes themselves are the supreme law of the land. And whenever the court has addressed that question, is a federal court, the statute, the supreme law of the land, it has always held, yes, it is.